Medicine is the oldest profession and one of the most humanitarian professions. Doctors are regarded as second lifesavers after God. Today I would be speaking to you about medical negligence. I would be covering my talk under the following heads: medical negligence as a civil liability, criminal negligence, vicarious liability, medical care in emergency situations, the defense of the medical profession, and finally I would conclude my talk. As we see the Black's Law Dictionary, the definition of negligence comes about as a conduct, whether of action or of omission, which may be declared and treated as negligence without any argument or proof as to the particular surrounding circumstances, either because it is in violation of a statute or in violation of a municipal ordinance, or because it is so palpably opposed to the dictates of common prudence that it can be said without hesitation or doubt that no careful person would have been guilty of it. As a general rule, the violation of public duty enjoined by law for the protection of person or of property. We observe that in recent times there has been a significant increase in the cases of alleged medical negligence. When we look at the causes, it appears to us that the reasons are as follows: greater consumer awareness, flexible consumer courts, high cost of healthcare services, and finally a litigant mindset of people in general. There are few basic elements of negligence, which are A duty of care, B, breach of that duty of care, C, the cause in fact, and D, the proximity of cause, and finally there should be an element of damage. These are the basic elements of negligence. Well, there is an exception to this. In case the services are provided free of cost, then there is no element of negligence. As we all understand, human body is a complex machinery. So as long as the doctors follow a practice which is acceptable as a standard of care, he shall not be held liable for any negligence. In case there is a better alternative or a more skilled doctor was available to do the same thing, this cannot be imputed as negligence. There is a maxim called as res ipsa loquitur, which says that the burden of proof lies on the defendant. This rule cannot be applied in case a method of treatment has failed. As we have said, negligence is a breach of duty caused by omission to do something or doing something which a prudent doctor would not do. So if we say what are the few things, essentially the components are a duty of care, breach of that duty, and resultant damage. The Honorable Supreme Court and the National Commission for Consumer Disputes have dealt with all these issues at length in their various judgments. Well, when we talk about criminal negligence, it has come to notice that indiscriminate prosecution of medical professionals for criminal negligence would be counterproductive and does no good to society at all. To impose a criminal liability, it should be proven that the accused did something or did not do something which no medical profession in his ordinary sense would have done or not done. The key word for criminal negligence is gross negligence, or we can also call it recklessness. Please appreciate that criminal process once initiated against a doctor, it subjects him to serious embarrassment, and in several times it also causes harassment to the doctor. he has to seek bail to escape arrest. At the end, he may be exonerated, but the loss he would have suffered by then to his reputation cannot be compensated by any standards whatsoever. Many a complainant prefers to take recourse to criminal process as a tool for pressurizing the medical professional to extract uncalled for or unjust compensation. Such malicious proceedings have to be guarded against. The Honorable Supreme Court has held this in Jacob Matthew versus State of Punjab and another. The other issue which we are to deal today is the issue of vicarious liability. There is an old Latin maxim, qui facet per alium facet per se, which means that one who acts through another acts in his own interest. We find that if any hospital staff who is an employee were to be negligent in the performance of his duties or their work, then the hospital would be held liable for their acts of negligence. This is exactly the issue of master-servant relationship. Various Supreme Court judgments and NCDRC judgments have explained the position in this situation. Hospitals have also been held liable for not providing adequate medical facility, as was held in Paschim Bengal, Khet Mazdoor Samiti and others versus the state of Bengal. In one instance, you'll be surprised to know that hospitals was held vicariously liable when they did not provide proper sanitation facilities, as happened in a case of M. Ramesh Reddy versus state of Andhra Pradesh, in which a patient fell down in the toilet due to improper conditions and sustained a hip fracture. So this is a bit about vicarious liability. Well, it's very important to deal with the subject of medical care in emergency situations. Honorable Supreme Court holds that the right to life enshrined in the Indian Constitution in Article 21 imposes an obligation on the state to safeguard the right to life of every person, and that preservation of human life is of paramount importance. The obligation of the state stands irrespective of the financial resources it has. Well, the Honorable Supreme Court has held that preservation of human life is of utmost importance. It is so on account of the fact that once life is lost, the status quo ante cannot be restored, as resurrection is beyond the capacity of any man. It is expected that in emergency situation, every doctor, whether at a government hospital or otherwise, has the professional obligation to extend his services with due expertise for protecting life. No law or state action can intervene to avoid any delay or avoidance of the discharge of this paramount obligation, which is cast upon members of the medical profession. The obligation is total, it is absolute and paramount. It has to be well understood that laws of procedure, whether in statute or otherwise, which would interfere with the discharge of this obligation, cannot be sustained and must therefore give way. Having covered this, I would now talk about the defense of the medical profession. In defense of the medical profession, Supreme Court has held in Kusum Sharma and others versus Batra Hospital that the law of negligence has to be applied according to the facts and circumstances of individual case. No one can ignore that medicine is an evolving science, and there is no precise outcome of effect for every person. The operations involve certain calculated risks which cannot be denied because of complications in the operation, if some risk has to be undertaken. And if some risk is happening, the doctors cannot be held responsible or liable for negligence, because the patient himself has consented to the risk which is involved in the surgical intervention. In the case of Jacob Matthew versus State of Punjab and another, the Supreme Court held that in some cases of medical profession, the doctors are equipped in certain situations where they have to make choices between a devil and the deep sea. Sometimes in certain situations, there may be greater risk in the operation, but there are also higher chances of success. And in another move, there would be lesser risk but higher chances of failure. So the decision that which course would be followed will depend on the facts and circumstances of the case. Well, this was the defense of the medical profession. So friends, having heard all this, now to sum up and conclude, we must say that on the scrutiny of leading medical negligence cases of India, certain principles should be taken into consideration while pronouncing the judgment in medical negligence cases. 1. Negligence should be guided upon the principle of reasonableness of common man prudence, and negligence must be established in order to give the compensation in certain cases. 2. Medical profession requires certain degree of skills and knowledge, so the standard of care in cases of medical professionals is generally high and should also be taken into account while giving the judgment. 3. A medical professional can only be held liable when the standard of care is reasonably and is less than reasonable care that should be taken from a competent medical practitioner in that field. Fourthly, when a choice has to be made between certain circumstances when there is higher risk involved and greater success is involved and lesser risk with higher chances of failure, the facts and circumstances of the individual case should be taken into consideration. Fifth, no negligence will apply on medical professional when he performs his duty with utmost care that should be taken and he had taken all the precautions. And finally, medical professionals should not be harassed unreasonably and unwarranted, and fear and apprehension should not be created on the medical fraternity that they can give their best in certain cases where it is required. They should be given some liberty in certain peculiar situations where they need to make their judgment without any apprehension freely, so that it can be beneficial for the society in the long run. Thank you very much.